Item 9A, public hearing, zone text amendment number 19-15. The applicant, the City of Carson, request a motion to amend something previously adopted, the November 24th, 2015 recommendation of approval of a comprehensive update of the city's oil and gas ordinance regulating petroleum operations and facilities.
This is a rather unique motion that we typically don't see in a planning commission. I think in the last 15 years, this is the first time I've seen it at a planning commission or city council. Basically what this motion does is allows the opportunity at the request of a planning commissioner to be put back on the agenda to reconsider a vote which was previously done. The staff report sets forth the parameters for that as to whether or not that can move forward. If there is not a first or a second or 5 people voting in favor of the motion, the original decision stands.
The chair will not open a public hearing. We'll go ahead and discuss and ultimately vote on related setback item only.
Mr. Chair.
Commissioner Andrews?
We voted on this twice, and it says in the staff recommendation that we would move so if we're inclined. So at this point, I would like to make a motion that we not even go through this process and that we move the the oil code up to city council as we voted on previously. So I would just like to make a motion that we move forward and move this thing on to city council. I don't see the need to belabor this. We've already voted on it twice.
I second.
Is there a second? Is there a substitute motion?
Mr. Chairman,
Commissioner, Mr. Vice Chairman Madrigal?
I'd like to bring a substitute motion to the table. I want to bring the motion to amend something previously adopted. Specifically, I move to amend the previously adopted Planning Commission motion related to item 9A with regard to the issue of setbacks as follows. Setbacks be set at 750 feet for section 9521A 1 to 3 and 9521D 3. All other adopted recommendations of approval, including those related to CEQA findings, remain the same. That is my motion.
That's a substitute motion. Is there a second? Commissioner Cinco. Okay, we'll vote on the substitute motion first. Madam Secretary.
Chair, before we vote, is there
Commissioner Thomas?
I apologize. Is it possible that we could ask a couple of questions of the oil interests that are in the room?
Mr. Chair.
I'd rather not, since I didn't open a public hearing for the rest of the folks that are out there. We'll call for the substitute motion. A vote, please. Madam Secretary.
Okay, substitute motion for 750 feet. Commissioner Andrews?
No.
Commissioner Cinco? Commissioner Palmer?
No.
Commissioner Matoma?
I'm abstaining.
Commissioner Thomas?
No.
Commissioner Pimentel? Commissioner Post?
No.
Vice Chair Madrigal?
Yes.
Chairman Diaz?
Yes.
Motion fails.
Now call for the original motion.
Commissioner Andrews?
Yes.
Commissioner Cinco?
No.
Commissioner Palmer?
Yes.
Commissioner Matoma?
I'm abstaining.
Commissioner Thomas?
Yes.
Commissioner Pimentel? Commissioner Post? Vice Chair Madrigal?
No.
Chairman Diaz?
No.
Motion fails.
Well, at this point, because both motions have failed, you can bring another motion. And I think, Chairperson Diaz, I think maybe allowing some questions would be a good idea, because if there are commissioners that are undecided and there's an issue that can be clarified, I think that would be a good idea, right, Mr. Farfsing?
In light of that, I would go ahead and allow some questions of the commission.
I have questions.
I would like to ask a question of Ted from E&B and any other oil interests that are here. Again, I'm not going to mince words. I'm just going to cut straight to the chase here. The dispute or the discussion at this point is the commission has already passed 1,000 feet setback. There has been a suggestion to possibly move that to 750 feet. Will you not challenge the 750 feet? I want to be clear. Will you be challenging 750 feet?
When define challenge?
Challenging meaning legal challenge.
Like
lawsuit.
Okay.
Lawsuit.
I just want to be clear.
And again, I want to be clear that my question is not just to you, any other oil interests in the room. So get ready.
Yeah, Mr. Thomas, the question is direct to this individual.
I apologize, but
okay. Commissioner Thomas, to answer your question, at this time we are not considering any legal challenges at a lower at 750 feet or lower.
If we approve 1,000 feet, what does it do to your oil operation?
Well, currently, thank you, Commissioner Matoma, for your question. As you all know, the current code is 300 feet. Every time we go above that, it devalues our assets. So if from going from 750 to 1,000, devalues our assets.
But does that limit your ability to drill?
Yes, all of the majority of our sites are within 1,000.
Yeah, that's what I understand. That if we approve 1,000 feet, basically we're taking. Is that correct?
Yes, that's one way to think of it. Yes.
Because we're not allowing you to drill on your land.
That's correct.
Because my original assumption was, and the reason I proposed 1,000 feet was that you were grandfathered, and that this 1,000-foot setback did not affect you.
Well, I guess to clarify, there's two different things. One is our vested rights.
Right.
So that's limited to a certain amount. Now, going beyond that, that would be under my understanding under new development. So this would this would impact our business.
You know, I think one of the things that we presented to you last time we were before you on this item was that there will be a substantial reduction of the acreage that will be available for doing some of the exchanges and moving away from the sensitive uses, which is what partly the intent of the ordinance was. And I think what we presented to you was approximately 1,200 acres within the city that would not be available as you move farther away. Now, that consideration was made basing it on 500 foot to 1,000 feet. So obviously there is a lesser amount than that when you consider 750 feet. So that, I think...
When you say lesser of acreage...
Lesser acreage, correct.
You're talking about the acreage that they currently have vested rights on. Is that right? Because my concern is new development. That's my biggest concern. You have new land, you go on the land. I don't want, I want basically 1,000 feet away from anybody's home. So the question for me was, and that's what I assumed that we did with 1,000 feet. I did not know that by passing this, that it limited your vested rights and it made a disincentive for you to move your wells back from the current setback.
At 1,000 feet, there's no incentive.
There's no room. You'd actually be up against some fence or something, right?
What plans would you be making toward the incentive program to move some, all, any of your wells from sensitive locations?
Well, I think I can't speak on that right now, but because we're talking about a scenario that is not put in place, but I can certainly come back with an answer.
I just want to understand, because when we talk about feasibility, okay, I get it, it's not feasible, but assuming that you get it and you still don't move forward with the incentive plan in any way, shape, or form, it sounds like a bit of a bill of goods.
That's the same.
Commissioner Matoma?
Okay, what's your opinion, Sonny, in regards to if we pass 1,000 foot? What's your opinion regarding the probability of a lawsuit?
I think you can ask the plaintiff. I mean, we have received over how many letters threatening lawsuit over that issue? Again, I cannot speak for the oil industry, for the plaintiffs, but there has been over 9-10 letters at the very least threatening lawsuits over that.
We can still be sued and still have to revert back to that 2-page code. So I'm of the mindset that if we're going to get sued, let's fight for our citizens. I mean, I don't get this. I really don't, and I'm frustrated by the fact that I have to go through it again, and we've already voted on it twice. It's just like you continue to get a bite out of the apple until you get what you want. We've already voted. I don't get this.
Thank you, Commissioner Andrews. Vice Chair Madrigal.
I'd like to resubmit my original motion. I don't want to state it all, but I want to reiterate that would be at 750 feet setback.
There's a motion to reinstate his substitute motion that was originally made of 750 setback. Is there a second? Commissioner Cinco, there's a second. Now we'll move to the 750-foot setback motion.
Commissioner Andrews?
No.
Commissioner Cinco? Yes. Commissioner Palmer?
No.
Commissioner Matoma?
Yes.
Commissioner Thomas?
No.
Commissioner Pimentel? Yes. Commissioner Post?
No.
Vice Chair Madrigal?
Yes.
Chairman Diaz?
Yes.
Motion passes.
The Government's a Sunshine Project is brought to you by Charles Thomas for Carson City Council 2020.